Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Back to talk to you about YNW Melly. We had talked to you recently and told you that Monday there were going to be some more hearings, and now the defense just filed an emergency motion to continue Monday's hearing. Let's see what they told the court. So they're saying that unfortunately when they set the hearing, they didn't realize that the attorneys were actually not available, and they had some conflicts, and Mr. Finling is not able to appear. And what else is also interesting is it says additionally there's some supplemental discovery. That means additional evidence that is going to be provided by the state that might be subject to argument. So what could that be? We don't know yet. The parties are working together to ensure that all the discovery is complete. They're saying also that they want to review the intended exhibits. There was a lot of talk about some of the evidence that they want to bring forward because they need to figure out what is going to be allowed in the trial or not. The judge needs to hear it in advance. And so in order to streamline the process, they're going to get together and go over the exhibits, and that way, if the defense has an objection, they'll focus only on the things that the defense is objecting to. And that just cuts out some of the time that everyone's going to be in court over these kind of housekeeping things. So it's a short motion. It's really just a one-page motion, and the state has no objection. So they're not opposing continuing, canceling Monday's hearing and them working out the evidentiary issues as much as they can in advance. And the courts usually favor that because they'd rather us work together, and then when you go in front of the judge, it's more narrowed. The judge's focus is just on what is being presented in court instead of wasting time with all the back and forth for each individual exhibit. They can actually create a list and have it in a way that's more easily presentable to the judge. So they're not ready, they need more time, and the state doesn't oppose it. So what does that mean for us? It kind of depends on how long it takes them to get this stuff together. We still have a looming trial deadline by the 21st, so we'll see if they're going to be able to schedule or reschedule this hearing. There is still the matter of the 10 days that the judge gave the state to specify on the gang enhancement or the gang activity where they granted the defense motion for statement of particulars. That's still kind of out there, but really not a big deal because that's something that's going to be decided or brought to the jury after they deal with the tampering. So I don't really see that getting in the way. So right now I think it's just the big issue here, and what is noteworthy is that there is supposedly some supplemental or new evidence that is going to be given to the defense. There's a possibility that that could be subject to suppression, which means the defense might be filing a motion to keep that out, which would require a hearing. And so again, this just leaves a lot of moving parts and no real clarity about whether or not this is actually going to go down starting on the 21st or if the trial is going to end up getting pushed back. So I appreciate all the comments in the chat, and some of them I've been able to answer and some I'd like to answer here. Funny, I was asked whether or not I would take this case, and that's a good question. And because I'm not a public defender, I also don't work for someone else. I have the ability to pick and choose which cases I take. For the most part, if you have a triable, defendable case and argument, absolutely, I'm all about taking it. Does that mean someone that doesn't, I'm not going to take the case? No. People a lot of times will ask, like, why would a defense attorney take a case if you know the person is guilty or if it looks like they're guilty? And so I think it always depends. The state has to be able to prove the allegations because God forbid somebody else was being charged with that and they really are innocent, and this is the only evidence that they're using against that person. So when we take on a case, it's kind of with that in mind. It's holding the system to account to make sure they are doing the right thing and not just selectively prosecuting people. My favorite cases are the cases that my client has a story. So I would only know after I meet the client. Like if someone on behalf of somebody who's in jail and they're like, hey, I want you to take this case, I'm not going to just take the case because they pay me to go take the case. I want to speak to the client. I want to know what their story is. I want to know what defenses we have available, and I want them to understand, like, this is the likely outcome. This is what we can do. I'm not going to make false promises. I'm going to make sure that they understand everything and they're on board with that, because otherwise what ends up happening is people get sold a lie and they think that, oh, you know, this person's going to get me off because I hired such and such attorney. I mean, you can't change the facts. So you need someone who's going to advocate for you, fight for you. There's certain things that the law just doesn't let us get around. And so if the client doesn't understand that and there's unreasonable expectations, no, then I'm not going to just take a case if we're not clear what the goal is, what the likely outcomes are, what the paths we can take. And obviously no one can guarantee what's going to happen, but we just need to be on the same page. And so it's not so black and white to just say, yes, I'll take this, or no, I won't take this. Someone talked about, can Melly's girlfriend plead the Fifth? It depends. So the Fifth talks about the Fifth Amendment in the Constitution that says you have the right to remain silent. You have the right to not incriminate yourself. yourself. And that is only relevant if you are facing criminal sanctions. So like someone in a lawsuit can't plead the fifth unless it has criminal implications. So it would depend on whether or not whatever she is trying to protect or not testify about exposes her to criminal liability. And if so, yeah, she could plead the fifth. And it's very likely that she may not. And she would be entitled to an attorney, and then they would advise her about what she can or can't say, what she does have to answer and what she doesn't have to answer. So we'll see. And it's still unclear whether or not they're going to bring her, or even if they bring her, what all she'd be open to saying. Now, I don't know if you guys have seen this, but apparently there's some video with Melly on the phone with a girl, like from his cell, and that's going around social media now. So I don't know who the girl is, and arguably, I guess the theory is that maybe he's talking to some other girl. What if Mariah, if she has any kind of feelings and then sees that Melly's talking to some other girl, maybe that's gonna change how she looks at what she has to say in his case. But I mean, even if she did, and that's the basis, then the defense could always cross-examine her about that. Wasn't it true? You saw this video and this bothered you, but before, you know. So I mean, there's a lot of different things that could happen, and you just got to be careful of how much weight or credit you give to what you see online. The only thing that's going to matter is what actually comes out in the courtroom. It's not uncommon that the lead attorney may not necessarily take the lead in a motion hearing, especially in this situation. The billion-dollar lawyer he referenced is actually barred and licensed in the state of Georgia. And so he filed a motion to get permission to basically appear on a one-off, like not all the time. If a lawyer wants to take a case in a different state, normally they can't practice law in the other state unless they take the test over there. It's a different test because the law is different for every state. Now, federal law is the same everywhere. So I'm licensed in federal court here in the Middle District, but with that, I can practice federal law anywhere in theory, and it doesn't change because the law is the same. But state courts are very specific. The law on murder and the degrees and all of that vary from state to state. And you probably hear that when you watch the different court cases and how they describe them. So the head lawyer here that just came on the case, he's from Georgia. The lawyer that was arguing these motions is actually from Florida. If you want to get permission to come in and be an attorney for one case, you have to have local counsel, like a local attorney that's going to be kind of like your point person for that state. And so that's who this attorney is. And so it makes sense that she would argue the motion that's on the Florida law rather than the other attorney. I went back and took a look at that video that's been circulating online, and it's very likely AI generated. Again, why you have to be careful not to make assumptions based on things that people are posting online. So we'll have to see what actually plays out in court, but that really looks a little suspicious. But what's even more interesting is, as I was going through this, I noticed that just today, the defense actually filed a defense witness list. So anytime in a criminal case, the state always provides its list of witnesses. And then the defense, if they have any witnesses that they're going to use, whether it's for a hearing or for a trial, they have to let the state know, and that way the state is on notice, and if they want to take depositions of the defense witnesses, they can. But check out who's on the defense witness list that was just filed today. Officer Garrett Steele, Officer Danny Polo, the unmasked detective, Officer David Alvarez, Officer Kevin Correa. Then there's a Christopher Barries, which is an attorney out of Brevard County, and I saved the best for last, Mariah Hamilton. What? So Mariah Hamilton is being listed on the defense witness list in the tampering case. What does that mean? What could that mean? We don't know, right? But definitely they have access. Maybe. Sometimes I might list a witness even if I haven't spoken with them and I think that I need them and I want to be able to subpoena them, but that would be very, very rare that you list a defense witness that you don't already know what you expect them to testify to. So this basically tells us that for some reason they need her testimony, because how we kind of talked about, we don't know if the state's going to bring Mariah Hamilton. We don't know if she's going to testify for them. The defense did this so that they are able to call her, regardless of whether the state calls her or not. And then what about these other officers and the attorney? I have no idea, but it's very interesting, and it really shows that the defense came to play. So that just shows that Anyways, that was unexpected for me, and I wanted to tell you guys because it is clear that the defense came to play. And then one last thing, right at 3:25 p.m., the state files a state supplemental discovery. So again, a notice giving the defense a heads up of some additional things that they're going to be providing to them. And in it, it's only one page, but it's got a lot of stuff in it. And it looks like there's two witnesses, one with a strategic investigation division, Fort Lauderdale, someone else, again from Vieira, I think it's related to the jail or custodian of records for the jail. And then certified copy of Melly's 2019, the murder case, certified copy of the entire court file for that case. Same thing for Cortland Henry's case, the warrant and affidavit to seize Mariah Hamilton's cell phone, warrant and affidavit for the search of Mariah Hamilton's cell phone, and then everything that they downloaded pursuant to that administrative search warrant, and warrant and affidavit for the search of Mariah Hamilton's cell phone. And all of that is because the defense actually wants to see the warrant and affidavit. What did they use? They talked about it at the last hearing, that when you file a motion to suppress, you can challenge the four corners of the warrant, meaning did what they put in there, did it give a judge enough probable cause to actually get to search the phone? And they want to challenge that, but they need to see the affidavit, and that's what this is providing them. Then the full download of Mariah Hamilton's phone pursuant to the search warrant. They put pone, typo. Anyway, we know what they mean. And then all the financials, and it has a list of all of these banks, which is interesting. Cash App for Henry and Hamilton. And obviously this is going to be the paper trail. If their allegation is that someone is paying someone off and that's how they're tampering, all this financial is probably linked to whatever they are alleging is how the payments were made and how they're trying to control somebody based on these payments that may be going back and forth. So it's this whole list of like 12 different financial institutions that they're receiving records from. Again, this is a big deal and a big change, and obviously they're going to need some more time to review everything that just came in. All right, I appreciate you guys as always watching. Keep the comments coming. I love the questions, and we'll be back with more updates as this thing unfolds. Okay, take care.